In some ways, it's challenging to be a lawyer in an organisation which is not primarily a legal organisation, because you are kind of, as I said, a small cog in a much bigger machine. Part of my job as a lawyer within a campaigning human rights organisation is to look at new legislation and think about whether or not it's compatible with existing human rights protection. The last 4 years has seen huge swathes of new legislation designed to kind of limit protest rights. So from creating new criminal offences to broadening police powers to limit protests. But there are other ways in which the police have been handed greater powers, for example, to control static demos rather than just marches. They now have the power to place limits on those as well. Protest rights are respected, and that people do have the right to demonstrate and to make their voices heard on the issues that they believe in.
Welcome to the Legally Speaking podcast. I'm your host, Rob Hanna. This week, I'm delighted to be joined by Katy Watts. Katy is a solicitor at the human rights organisation Liberty. Katy leads its legal work on protests and works across technology, surveillance and data rights. Katy has been leading the case against the Home Secretary over protest laws. Before joining Liberty in 2020, Katy worked at a leading public law NGO and the Public Law Project, where she specialised in strategic judicial review litigation concerning access to justice and migrants' rights. So a very big warm welcome, Katy.
Hi Rob, very glad to be here.
Oh, it's a pleasure to have you on the show. And before we dive into all your amazing projects and experience to date, we do have a customary icebreaker question here on the Legally Speaking podcast, which is, on the scale of 1 to 10, 10 being very real, what would you rate the hit TV series Suits in terms of its reality of the law, if you've seen it?
Well, I haven't seen it, so I'm not sure I can answer that question.
So with that, we're going to give it a quick 0 and move swiftly on to talk all about you. So to begin with, Katy, would you mind telling our listeners a bit more about your background and career journey?
Yeah, sure. Well, as you said at the outset, I'm a solicitor at Liberty, which is a human rights organisation. And before that, I worked at the Public Law Project, which is another NGO. So in lots of ways, it's been quite an unusual career journey in that I've never been a solicitor in private practice. I've always worked in the NGO sector, trained and qualified at the Public Law Project, as well as working there for 4 years post-qualification. And before that, I worked in the NGO sector as a non-lawyer. So it's a bit of an unusual journey. I didn't go down the kind of traditional training contract route.
Yeah, and we like people with different backgrounds, and it also opens people's eyes to different routes into the law as well, which I think is great. But talk us through some of your sort of motivations. What motivated you specifically to pursue a career in human rights, justice and migrants' rights?
It's a good question. I think, so I studied politics as an undergraduate, and I looked at law when I was coming to the end of my undergraduate degree as something that felt like perhaps a kind of natural career move. It sort of fits quite well. Politics and the law often go together. And I sort of had an idea then that I wanted to do something that would be sort of practically useful, I suppose. And so I did do a law conversion immediately after my undergraduate degree, and I actually found it extremely off-putting. I really didn't enjoy it at all. And part of the reason for that, I think, was not so much the kind of content of the law conversion, but just the sort of narrowness, I guess, of the kind of careers that I was able to find out about through that experience. It felt very geared towards funneling students towards careers at the sort of corporate end of the legal profession, so magic circle firms, commercial firms. And I kind of looked into those kinds of training contracts. It really didn't feel like it was for me. It felt much harder to access information about like what other kinds of legal careers might look like. And so I ended up not pursuing law at the end of that process. I kind of opted out of a legal career. I didn't think it was necessarily forever, but I went and did a variety of different jobs working for kind of charities, including the British Red Cross, where I worked with refugees and migrants, and at a social justice charity called Toynbee Hall. And it was through doing that kind of work in the like charity and NGO sector where I felt very at home, but I also started to be exposed to lawyers who were practicing in those fields through lawyers who came and volunteered at projects that I was working on, or just often, especially with the work at the Red Cross, we would often need to refer service users to lawyers to take up their cases when they were experiencing kind of really significant legal problems. And so that really opened my eyes to the kinds of firms that were doing the work that I was interested in, and the kind of legal career that I had sort of initially imagined when I thought about doing a law conversion, and that just felt much more suited to what I wanted to do than those kind of commercial firms and commercial training contracts that had been the focus, I guess, of the careers advice I'd had at an earlier point.
And there's a really good nugget in there of sort of, you really put deep thought into your career ahead of your years and what matters to you and your values, and you've stood to them. And obviously, as a result of that, you've had a wonderfully successful career, probably full of fulfillment, rather than this is the traditional path you should potentially think about going. And actually, it isn't quite in the back of your mind what you really want. So I think that's really good, a case study there for people to follow who might be feeling like, oh, this seems to be the only option. Actually, there's so many different options. And that's why we do this show, to kind of open people's eyes to, if you want something in and around the law, there probably is something for almost everybody. So let's dive in a little bit more about some of your past experience, because whilst at the Public Law NGO and also the Public Law Project, what type of work were you getting involved with?
So I was really lucky that the Public Law Project, just at the time that I was starting to think that maybe I would look for training contracts again, and was looking at the kinds of firms that specialised in the areas of law that I wanted to practice in. The Public Law Project had some funding to offer a training contract through a scheme called the Justice First Fellowship. It was about 10 years ago now. And so I applied to do a training contract there. I was the first trainee they'd ever had. And so it was a real variety of work. I mean, in many ways, it was quite narrow because it was very focused on public law. But it was back in 2014-15. There were lots of challenges to huge cuts to legal aid provision. And the Public Law Project was engaging in a lot of kind of very strategic, targeted litigation, trying to mitigate the worst effects of those cuts on access to justice. And so for the first few years that I was at the Public Law Project, both during my training contract and afterwards, my work really focused on bringing quite high-level strategic litigation all the way up to the Supreme Court, challenging various different cuts around access to legal aid, including cuts which would have affected victims of domestic violence, cuts which would have excluded people who could not prove lawful residency in the UK, and various other types of cases from being able to access legal aid. And so that was very, I guess, important in the experience that I got of bringing very targeted, thoughtful, strategic litigation in the public good, which is, I suppose, what I've kind of continued to do for the rest of my career.
Yeah, and very well done so along your journey as well. So to the present day, you're now a solicitor at Liberty. What does Liberty stand for?
Liberty is a campaigning human rights organisation. We celebrated our 90th anniversary this year, so we've been around a long time, and we were founded in 1934 to protect the right to protest. That's still one of our core kind of functions. I mean, we work across a lot of different areas now. So we're not just a protest organisation. We try to kind of defend people's rights and stand up to power. And we do that not just through the legal team. So I think people are often surprised if they've heard of Liberty to know that we have a legal team of just 4 lawyers. So it's a very small legal team within the kind of context of the organisation. We also have, we do campaigning and lobbying and policy work. And I think one of the things that's been interesting for me about working at Liberty is, I suppose it's more of an in-house role in lots of ways. The legal team is a small cog in a much bigger machine. And so our legal work focuses on various different things. As you said in your intro, I work on protest. I also work on technology, surveillance, and my colleagues work across issues like discriminatory policing practices and the criminalisation of poverty and homelessness. But as I said, my work mainly focuses on protest rights. And over the last 4 years, we've seen huge amounts of legislation which have targeted people's right to protest and to stand up for what they believe in. And so that's been a real focus of our work, is thinking about how to challenge that legislation in a strategic way to protect people's rights.
Yeah, no, and thank you for giving such context around that. And obviously, it's very important work that you're doing. This might be quite a hard one to pin down, but what's been the most rewarding aspect of the work you've been doing at Liberty?
Yeah, it's a good question. I mean, lots of it is very rewarding. I think one of the things that I find most rewarding about working in Liberty, as I said, in some ways it's challenging to be a lawyer in an organization which is not primarily a legal organization, because you are kind of, as I said, a small cog in a much bigger machine. But the kind of benefits of that are also huge, because I get to work with colleagues who have expertise, in different disciplines, real policy expertise, campaigning expertise, and also work not just with my own colleagues, but with organizations who are kind of on the front line of working on some of these issues. And so one of the really rewarding things I think about working at Liberty is working with grassroots organizations, working with campaigners, with activists, with community-led groups, and kind of trying to build, as I said, sort of a strategic legal response to issues that we care about. So it's not just about bringing cases which Liberty wants to bring. We try to take a very sort of thoughtful and considered approach and try to work with other organizations, and also working, as I said, with my colleagues in the policy team to develop sort of legal strategies to think about how we can best tackle the issues that we care about.
Yeah, and again, I can just hear the passion in your voice, and the dedication to your profession. And I think it's very it's nice to hear, because I think a lot of people, as I said before, perhaps go into a career, go into a job, and it's very much that. But for you, I can really sense that this is so much more than a job. And obviously, everything that you fight for and everything you do is truly outstanding. Hey listeners, we hope you're enjoying today's episode of the Legally Speaking podcast. We want to take a quick moment to talk about something every lawyer can appreciate: saving time. That's why we're excited to introduce you to our sponsor, Clio. Clio, the leading cloud-based legal software, is changing how legal professionals manage their practice. With its unique suite of tools, Clio ensures you're covered whether you're in the office, at home, or on the go, making your job easier and more efficient. Imagine this: instead of sifting through endless paperwork and juggling multiple platforms, Clio offers a single integrated solution to manage your cases, clients, and billing. Their intuitive interface allows you to organize your tasks seamlessly, keep track of important deadlines, and communicate effortlessly with your team and clients. But the real game changer is the time you'll save. Firms using Clio can save on average 8 hours per week on administrative tasks. That's an extra workday you can dedicate to what matters: practicing the law and serving your clients. And it gets even better. Clio's powerful analytics and reporting tools help you make data-driven decisions to continuously improve your practice. It's like having a personal assistant always on top of things, ensuring you never miss a beat. So if you're ready to elevate your practice and reclaim your time, head over to clio.com/UK and start your free trial today. Trust us, you'll wonder how you ever work without it. Now let's get back to the show. And I guess that leads nicely on to the case you've been leading against the Home Secretary over the protest law that we've been kind of touching on. So would you mind, for our listeners who may be less aware, outlining the facts and the issues of the case, please?
Yes, I mean, as I said, the last 4 years have seen huge swathes of new legislation designed to kind of limit protest rights. So from creating new criminal offences to broadening police powers to limit protests. So this case arose, in 2021. The government laid a new bill, the Police Crime Sentencing and Courts Bill, as it was then, and we spotted right back then a provision in that bill which would give the Home Secretary the power, by secondary legislation at a later date, to amend the definition of serious disruption in existing legislation, which is relevant to when the police can impose conditions on protests. And at the time, working with colleagues in the policy team, we were concerned that this was a very broad Henry VIII power. So Henry VIII power is a power contained in primary legislation that allows you to amend it later by way of secondary legislation. And they generally should be used sparingly, and are often quite a sort of concerning way of the executive sort of handing itself powers to use later. So back in 2021, we sort of clocked that, I made a note, if the Secretary of State ever seeks to use this power to amend what is meant by serious disruption, we should look at whether or not that's been done lawfully within the scope of this power. So then fast forward a couple of years to 2023, and the government, slightly oddly, initially did not use that power it had given itself. It tried to amend the definition of serious disruption by way of primary legislation in a new bill, the Public Order Bill as it was then, and failed to get that through the Lords because the Lords were concerned that lowering what they tried to do was define serious disruption as any more than minor impact, and the Lords were concerned about that change. So it failed in the Lords, at which point they knew that they had a power, the 2021 power, and they tried to lower the definition of serious disruption to this more than minor definition, which would enable the police to place controls, place limits on protests where they reasonably believed that there would be any more than minor impact rather than disruption, which was serious. So at that point, we were concerned, well, for two reasons. First of all, that seemed to go beyond the scope of the enabling power to define serious. As I said, it lowered the threshold rather than defining it. And secondly, we were concerned at the kind of way in which they had gone about doing it. We understood that it was the first time that a government had ever tried to do something by secondary legislation that it had failed to do by primary legislation. And we were concerned that not only was that unconstitutional, but that was potentially unlawful to undermine Parliament's will in that way. That formed the basis of our first three grounds in the case. We also challenged the exercise of that power on a fourth ground, which was that they had failed to fairly consult on the changes because the government had carried out a consultation at number 10 with various policing bodies, but had failed to consult protest groups about what that change of definition would mean for the right to protest. So we challenged the exercise of that power on all of those grounds.
Yeah, and again, a tremendous amount of work would have gone into that, I'm sure. And on Tuesday, I believe the 21st of May, 2024, the judgment was handed down and Liberty called the ruling a huge victory for democracy. So what was the judgment and the outcome?
So the judgment and the outcome was that the court found that the regulations which change the definition of serious disruption or define serious disruption as any more than minor impact were unlawful. And so that is, a huge success for us. The judgment found the regulations to be unlawful on two grounds. So on ground one, which was a sort of straightforward ultra vires ground, that the Home Secretary, the enabling power, which gave the Home Secretary power at a later date to have defined serious disruption, only enabled her, it was Suella Braverman at the time, to define it. And what she had done was go much further than that and lower the threshold. And that by changing the definition of serious disruption to more than minor, that was ultra vires the enabling power, because it was not defining, it was not clarifying what those words meant. It was lowering the threshold, which gave greater power to the police. And so that was unlawful. The court also found that the consultation had been carried out unfairly. Well, first of all, it found that it had been a consultation. Interestingly, when the regulations were first published, the government themselves referred to a consultation that had taken place following pre-action correspondence. The published explanatory notes were amended and the word consultation was removed. And the government sort of tried to maintain that it had been a sort of targeted engagement with stakeholders rather than a consultation to which standards of fairness attached themselves. So the court in the judgment found that actually it had undertaken a consultation, and that because it had undertaken a voluntary consultation, that had to have been carried out fairly, and that the consultation that they had undertaken was one-sided and therefore not fair and therefore unlawful. So the court quashed the regulations, but following submissions from both parties, the court made a suspended quashing order. So although the regulations are quashed, the effect of that quashing is suspended pending an appeal by the Secretary of State for the Home Department.
Yeah, no, it's fascinating stuff. And I want to kind of just dive a little bit deeper into this because in a Liberty article, and this flows nicely from what you were just saying, says court finds government anti-protest legislation unlawful after Liberty legal challenge. You state, in recent years, the government has introduced a whole host of new laws which have tried to stop people from being able to speak up for what they believe in. So how have these laws affected people's ability to organize and participate in protests?
I would say that there have been two main impacts from the new laws which have been introduced. The first is handing the police greater powers to place limits and place controls on protests. As I said, that's what our case was about trying to ensure that the threshold at which police can interfere in protests was not lowered further. But there are other ways in which the police have been handed greater powers, for example, to control static demos rather than just marches. They now have power to place limits on those as well. But the new legislation has also introduced a range of new criminal offences. I think one of the notable examples of that is the offence of locking on or being equipped to lock on, which is an offence which comprises of attaching yourself or an object to another object, to another person, to land. And that was used to arrest anti-monarchy protesters at the coronation last year who had arrived for their protest with their placards zip tied together, and the existence of those zip ties was apparently being equipped to lock on. So we've seen these really kind of broad concerning offences, which I think can be used by the police, potentially to arrest and criminalise protesters. But I think it's also created an atmosphere really of uncertainty about what the law is regarding protest, because as well as the introduction of all of these new laws, there's been a huge amount of rhetoric from the government and from the police around protest. I think what that has led to is uncertainty by people about, to what extent protest is lawful, what kinds of protest offences there are, whether they may be criminalised for attending a protest. And that's really concerning.
Yeah, it is. And that again leads to what I was going to want to find out a little bit more from you on how do these laws conflict with existing human rights protections in the UK?
So I think that was something that we've been thinking about over the last few years as each of these new pieces of legislation is introduced to Parliament. Part of my job as a lawyer within a campaigning human rights organisation is to look at new legislation and think about whether or not it's compatible with existing human rights protections, and in particular with Articles 10 and 11 of the European Convention on Human Rights. The kind of conclusion that we have come to is that a lot of the kind of where it comes to the crunch is how those laws are used by the police. So creating new criminal offences per se does not necessarily breach Articles 10 and 11 of the Human Rights Act, of the European Convention, is incorporated by the Human Rights Act. But if they are used in a disproportionate way by the police to criminalise protesters who are exercising their right to free expression, then the exercise of those powers may well conflict with human rights law, and that it is likely, I think, that people are being criminalised in ways which engage and potentially breach their right to protest. You've also seen this with things like the toppling of the Colston statue in Bristol. Those protesters relied on their human rights in defence of the charges of criminal damage, and were successful in being acquitted. And what happened after that was the then Attorney General, Suella Braverman, referred that case to the Court of Appeal to try to limit the scope of what we call human rights defences, so relying on your human rights in defence in criminal proceedings. And so as well as new legislation which creates new criminal offences, gives the police greater powers to interfere in protests, we're also seeing kind of slightly insidious sort of creeping in of limits on how people can rely on their human rights in criminal proceedings through cases like the Colston 4 Attorney General's reference.
Yeah, no, interesting. Again, thanks for giving lots of case studies that a lot of people will be able to kind of think back to and understand. Let's look forward then. What potential changes or reforms would you like to see to ensure protection of free speech and protest rights in the UK?
I think one thing that I'm particularly concerned about is you've just used the language of free speech. In the UK, we have the right to free expression under Article 10 of the European Convention on Human Rights, and I think it's really important to remember that expressive acts can also be acts of protest and also attract the protection of human rights law. And I was just talking about the Colston Four and that act of tearing down that statue of the offensive slave trader, and I think what we're seeing at the moment really is a narrowing of what we understand by free expression to kind of a more pure free speech interpretation. And one thing that I would like to see is to kind of hold the line or even expand what we understand as free expression to not just speech, but also to those expressive acts of protest, which might encompass behavior and actions beyond speech. I think we would also like to see a lot of the legislation that has come into force over the last four years reversed. As I've said, part of the problem is how that legislation is used by the police, how those powers are used. But I think also, as I've said, it has created an atmosphere of uncertainty for protesters. And I think that a sort of strong signal that protest rights are respected, and that people do have the right to demonstrate and to make their voices heard on the issues that they believe in, is very important, and that the reversal of some of the more draconian measures that have been introduced over the last few years, some of the new criminal offences, some of the new powers to place civil orders on protesters, which kind of prevent them from engaging in protests, moves to reverse those would, I think, send a very strong signal.
Yeah, absolutely. And I guess a couple of final questions then, and we've kind of touched on this, but I'd love to get your sort of individual perspective. What do you envisage the future of human rights in the UK, and what role do you hope to play in that future?
I hope to see a world in which human rights are respected by the government, by the state, by local authorities, by all public bodies, and a society in which everyone's rights are respected and everyone is kind of free to live without those rights being interfered with. I think an ideal world is one in which liberty is not needed to help people. Not needed to ensure that people are able to stand up for their rights. We're not needed to act in cases where those rights have been infringed. I think an aspiration as well for us is not just to see the rights that we currently have respected, but to broaden the scope of what we understand by human rights, which are kind of currently framed in quite a sort of almost quite an old-fashioned framework. The European Convention dates to the 50s. It was very much formulated in a post-war, Cold War era when we were thinking about rights in terms of like that right to be free from surveillance by the state, the right to privacy, those kinds of freedoms. And I think that in 2024, we should maybe be imagining our rights as extending a bit beyond those kind of negative interferences from the state, and thinking about, well, what about a right to a home? What about a right to kind of economic security, a right to health? I think a really positive way of thinking about human rights for the future would be not just thinking about a life free from interference by the state, but about the right to kind of live a secure and happy life.
Yeah, and we all obviously want to be happy at the end of the day. So finally, what advice would you give to young lawyers and activists aspiring to work in human rights?
As I said, my career is a bit unusual. I spent several years working in the NGO sector at the outset, and I would say that it can feel very discouraging. I think the legal profession is obviously highly competitive in lots of different areas. I think the human rights sector can feel particularly competitive. There are fewer jobs, perhaps, than in other areas. And I think it can feel hard to access And it can often feel to students and young people, particularly people that I meet now who kind of have questions about how to access this kind of career, that there's a need to undertake a lot of work experience, to undertake unpaid internships, and that can feel very discouraging. I mean, what I would say is I was very lucky. The work experience that I did have absolutely helped me get that training contract. But that also it certainly doesn't have to look like unpaid internships or getting lots of work experience, but kind of, a commitment to activism, a commitment to human rights, a commitment to wanting to work on these kinds of issues is the most important thing when you're trying to demonstrate to those firms that do this work that you really care about these issues, and that's why you want a career in human rights law.
Yeah, absolutely. And I've got that loud and clear through this episode through the pleasure of interviewing you today. And I'm sure our listeners would like to learn more about your career, Liberty. Where can they go to find out more? Feel free to share any social media handles or any websites. We'll also share them with this episode for you too.
Yeah, sure. I mean, I'm always happy. My Twitter DMs are open, and I'm always happy to talk to aspiring lawyers and law students about my career and give tips if I can. So yeah, Katy W on Twitter.
There you go, folks. Well, Katy, it's been an absolute pleasure hosting you on the Legally Speaking podcast, learning lots more about your careers and the tremendous work that you are doing in human rights. But for now, from all of us on the Legally Speaking podcast, wishing you lots of continued success with your career. But over and out. Thank you for listening to this week's episode. If you like the content here, why not check out our world-leading content and collaboration hub, the Legally Speaking Club, over on Discord. Go to our website, www.legallyspeakingpodcast.com, for the link to join our community there. Over and out.